Legal consequences of partner. Any change in the relation of partners will result in reconstitution of the partnership firm. Thus, on admission of a new partner or retirement of a partner or expulsion of the partner, or on insolvency of a partner etc., a firm will be reconstituted. Legal consequences. Introduction of a partner. No person shall be introduced as a partner into a firm without the consent of all the existing partners. A person who is introduced as a partner into a firm does not thereby become liable for any acts of the firm done before he became a partner. A person who is introduced as a partner into a firm does not thereby become liable for any acts of the firm done before he became a partner. Rights and liabilities of new partner. The liabilities of the new partner ordinarily commence from the date when he is admitted as a partner, unless he agrees to be liable for obligations incurred by the firm prior to the date. Thus, an agreement between the partners and the incoming partner that he shall be liable for existing debts will not ipso facto give creditors of the firm any right against him. In case of partnership of two partners. This section does not apply to a partnership of two partners which is automatically dissolved by the death of one of them. Legal consequences. Retirement of a partner. A partner is said to retire when he ceases to be a member of the firm without bringing to an end the subsisting relations between the other members, or between the firm and third parties. A partner may retire with the consent of all the other partners, in accordance with an express agreement by the partners, or where the partnership is at will, by giving notice in writing to all the other partners of his intention to retire. Liabilities of an outgoing partner. As we have already stated earlier, a retiring partner continues to be liable to third party for acts of the firm after his retirement until public notice of his retirement has been given either by himself or by any other partner. But the retired partner will not be liable to any third party if the latter deals with the firm without knowing that the former was partner. The liability of a retired partner to the third parties continues until a public notice of his retirement has been given. Expulsion of a partner. The partner may not be expelled from a firm by any majority of the partners, save in the exercise in good faith of powers conferred by contract between the partners. The power of expulsion must have existed in a contract between the partners. The power has been exercised by a majority of the partners, and it has been exercised in good faith. If all these conditions are not present, the expulsion is not deemed to be in bona fide interest of the business of the firm. Legal consequences. Insolvency of a partner. Where a partner in a firm is adjudicated and insolvent, he ceases to be a partner on the date on which the order of adjudication is made, whether or not the firm is hereby dissolved. where under a contract between the partners the firm is not dissolved by the adjudication of a partner as an insolvent, the estate of a partner so adjudicated is not liable for any act of the firm and the firm is not liable for any act of the insolvent, done after the date on which the order of adjudication is made. Liability of estate of deceased partner. Ordinarily, the effect of the death of a partner is the dissolution of the partnership, but the rule in regard to the dissolution of the partnership by death of partner is subject to a contract between the parties, and the partners are competent to agree that the death of one will not have the effect of dissolving the partnership as regards the surviving partners unless the firm consists of only two partners. In order that the estate of the deceased partner may be absolved from liability for the future obligations of the firm, it is not necessary to give any notice either to the public or the persons having dealings with the firm. Right of outgoing partner. Certain cases to share subsequent profits. According to Section 37, where any member of a firm has died or ceased to be partner, and the continuing partners carry on the business of the firm with the property of the firm without any final settlement of the outgoing partner, then the outgoing partner or his estate is entitled at the option of himself or his representatives to such share of the profits. Provided contract between the partners. Provided that whereby contract between the partners, an option is given to continuing partners to purchase the interest of outgoing partner, and that option is duly exercised, the estate of the outgoing partner, as the case may be, is not entitled to any further or other share of profits. Analysis. It lays down a substantial law relating to a liability of the surviving or continuing partner, who without a settlement of accounts with legal representatives of the deceased partner utilizes the assets of partnership for continuing the business. Right of outgoing partner. Conditions to start a firm in same nature. An outgoing partner may carry on business competing with that of the firm and he may advertise such business, but subject to contract to the contrary, he may not use the firm name, represent himself as carrying on the business of the firm, or solicit the custom of persons who were dealing with the firm before he ceased to be a partner. Agreement in restraint of trade. A partner may make an agreement with his partners that on ceasing to be a partner he will not carry on any business similar to that of the firm within a specified period or within specified local limits, and such agreement shall be valid if the restrictions imposed are reasonable. Revocation of continuing guarantee by change in firm. According to Section 38, a continuing guarantee given to a firm or to third party in respect of the transaction of a firm is, in the absence of an agreement to the contrary, revoked as to future transactions from the date of any change in the constitution of the firm.